Welcome to the deep dive. We all think of contracts as, a simple trade. I promise to do X, you promise to do Y. But what happens when things get messy? Someone messes up, and the other party just says, that's it, I'm not paying. I'm done. Our mission today is to find that exact legal line, the nugget of knowledge, where one party's failure is so bad, so severe, that it legally allows the other person to just walk away. And to do that, we're diving into a case, K&G Construction Co. v. Harris. It's a 1960 case from Maryland that really gives us the perfect test for what the law calls a material breach.
Right. And to figure out if someone is legally justified in, say, withholding a payment,
Mhm.
we have to follow the court's logic exactly. It's really a three-step analysis. First, we have to check if the promises were mutually dependent. Second, we have to be sure any breach actually happened. And then the big one, third, we have to analyze the materiality of that breach. Did it go to the very heart, the essence of the deal?
Okay, let's start with that first concept then. Dependent promises. I know that way back when, courts used to assume promises were independent, which just sounds strange today. Why was that distinction so important, and who was the person who finally changed the rule?
Well, in early common law, your intuition is right. It was strange. Promises were seen as independent. So if I failed to do my part, you still had to do yours. Your only option was to sue me later for damages. It was an exchange of promises, not an exchange of performances.
That sounds like it would create absolute chaos on a job site.
It did. And the big change came in 1774. A judge, Lord Mansfield, in a famous case called Kingston v. Preston, basically said this makes no sense.
Oh.
He's the one who shifted the entire doctrine, establishing that one party's performance could be legally conditioned or dependent on the other party performing first.
And that's the standard we use today, that promises are, by default, dependent on each other.
Absolutely. The modern, almost universal rule is that we presume mutual promises are dependent. And for a construction contract like the one in K&G, it's everything.
So in a construction context, what does dependent mean for who has to go first, the builder or the one paying?
It means performance is conditional. So in our case, the subcontractor's promise to do the work in a workmanlike manner is what we call precedent. It has to happen before the general contractor's duty to pay is triggered. You have to do the work and do it right to earn that payment.
Okay, let's apply that rule directly to the conflict in K&G. Can you set the scene for us? What was the core dispute between the construction company and Harris, the subcontractor?
So Harris, the subcontractor, was hired for excavation work, and the contract was explicit. He had to perform in a workmanlike manner. K&G, the general contractor, had to make progress payments by the 10th of each month. The whole thing blows up on August 9th, 1958.
What happened?
A bulldozer operator working for Harris gets too close to the house they're working on, and, he collapses a wall.
Oh, wow.
Yeah.
Yeah.
It causes $3,400 in damage. The very next day, August 10th, the progress payment is due, and K&G refuses to pay. They argue the damage was a material breach of the contract.
And how did Harris, the subcontractor, react to not getting paid?
He actually kept working for about a month. But when K&G still wouldn't pay, he packed up and abandoned the job on September 12th. His argument was that K&G's refusal to pay was the real breach, and that justified him walking away. So it all comes down to who breached first and whose breach was material.
Okay, let's analyze K&G Construction Co. v. Harris. I want to walk through the court's reasoning step by step. First, what are the legally dispositive facts?
The key facts are pretty simple. A subcontractor performs negligently, causing $3,400 in damage. That amount was more than double the progress payment that was due the very next day. So the contractor withholds the payment, and in response, the subcontractor quits the job.
And what was the core legal issue the court had to decide?
The precise legal question was this: did the subcontractor's negligent work, causing all that damage, amount to a material breach? And if so, did that legally justify the contractor's refusal to pay?
So what rule of law did the court apply? Can you state the full black letter rule and then break it down into its testable elements for us?
Of course. The court applied the rule for material breach of a dependent promise. The rule states that an unexcused failure of performance, if it's so important that it amounts to a total breach, justifies the injured party in refusing to perform their side of the bargain. And that rule has three essential elements you have to prove. 1, the promises must be mutually dependent. 2, the poor performance must actually be a breach of a contract term. And 3, that breach has to be material, meaning it's a failure of substantial performance.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, mutual dependency?
Well, that one was easy for them. The court just applied the modern presumption. In a construction contract, the promises are dependent. They found the subcontractor's promise to perform correctly was a clear precedent to the contractor's promise to pay. So element 1 was easily met.
Understood. Now, what about the second element, identifying the breach?
The contract was very clear. It said the work had to be done in a workmanlike manner and in accordance with the best practices. Driving a bulldozer so carelessly that you knock down a wall is obviously not workmanlike. So that was a direct violation of an explicit term. The subcontractor definitely committed a breach, no question.
Okay, and here's where it gets really interesting. How did the court apply the third element, materiality of the breach? This is the vital question, right?
Yeah.
Was that $3,400 in damage bad enough to stop the whole train?
Exactly. This is the heart of the analysis. The sub-rule here is that a failure of substantial performance makes a breach material. So the court did something very practical. It just looked at the numbers. They compared the $3,400 in damages that Harris caused to the, I think it was $1,484 progress payment that K&G withheld.
So the damage was more than double the payment.
More than double. And because of that huge disparity, the court said the breach wasn't just some minor defect. It went to the very essence of the contract's value and quality. The sheer size of the harm made it material.
And after analyzing all the elements, what was the court's final conclusion regarding who was ultimately at fault?
The court concluded that because the subcontractor, Harris, committed the first material breach, K&G was completely justified in refusing to make that August 10th payment. They acted within their legal rights. And because K&G wasn't in the wrong, the subcontractor's decision to walk off the job a month later became its own separate total breach. So Harris ended up being liable for the extra costs K&G had to pay to get the job finished.
Okay, let's unpack this materiality concept because it really is the whole ballgame. Let's try a hypothetical. Imagine the subcontractor's bulldozer had just, say, scraped some paint off a corner of the house. The repair only costs $100. If the payment due was still that same $1,484, would K&G have been justified in withholding the entire amount?
No, absolutely not. And this is really the core lesson of the case. A $100 scrape would be considered a partial breach. K&G would have a claim for the $100, sure, but that tiny breach is not nearly severe enough to be a failure of substantial performance.
So wait, in that scenario, if K&G had withheld the whole payment over a $100 scrape, they would have been the one in breach.
Exactly, you've got it. In that case, K&G would have committed the first material breach by improperly withholding payment for work that was substantially complete. Then, the subcontractor, Harris, would have been legally justified in walking off the job. The case turns entirely on the sheer magnitude of that $3,400 damage. It was the size of the harm that mattered. So, for anyone listening who's trying to analyze one of these disputes, here's the actionable checklist you should use. It's a diagnostic tool. First, issue spotting. Find the initial failure. Did someone fail to perform with care? Did someone fail to pay? Second, the dependency check. Are the promises linked? In modern common law, the answer is almost always yes. One performance is conditioned on the other. Third, and this is the big one, the materiality test. You have to compare the magnitude of the harm from the breach against the value of the performance being withheld. If the damage is so significant it prevents substantial performance, then it's material. And finally, fourth is the consequence. If the breach was material, the non-breaching party can stop performing. But if it was only partial, they have to keep going, or their own stoppage becomes the new material breach.
So the key takeaway from K&G is that stopping performance-like withholding payment is a powerful tool, but it's a tool the law only gives you when the other side's failure is genuinely severe. It has to be material, and materiality is measured by the size of the injury.
Right.
You can't use a tiny flaw to get out of a huge payment. And before we go, there's one last interesting point. The subcontractor argued that since he had liability insurance, that should have sort of excused his negligence. The court completely rejected that. They said insurance is not a license to perform in a careless, negligent, or unworkmanlike manner. And that raises a really important question for you to think about. In our world of complex contracts where everyone has insurance, does that coverage ever truly reduce the fundamental duty to perform your job with care? Or is that duty to do good work always primary no matter what? Something to think about.